All right. So you've now met Andres and I. Just a quick introduction on our presenter and discussant for this first part of our session. Yihao Yuan is an assistant professor of marketing at the UCLA Anderson School of Management. Professor Yuan studies empirical industrial organization with a primary focus on vertical contracting and the economics of digitization. And as our discussant, Yihao is the Charles R. Schwab Professor in Economics at Stanford University and a research associate in the National Bureau of Economic Research, where he directs the Industrial Organization Program. My goal today is for each presenter to have 15 minutes for their presentation and then the discussant to add comments for 5 minutes. Andres, would you like your time after each session or wrap it up at the end?
I'll take it up.
Okay.
Thank you.
Okay, great. Professor Yuan.
Thank you. Thank you for including my paper in this program. And today I'm sharing my paper titled Exclusive Contracts in the Video Streaming Market. In the video streaming market, streaming services like Netflix and Hulu often license titles from external studios like Universal and Paramount. And among these licensed titles, 87% are available on just one streaming service. And such exclusive distribution is often enabled by exclusive contracts where a studio commits to distribute a title to only one streaming service. For instance, Netflix had an exclusive contract with Warner Brothers for Friends and Hulu with FX Networks for Four. Despite their prevalence, exclusive contracts are controversial. And to understand why they are controversial, it's important to understand the forces that drive their prevalence. And there are two main reasons. First, streaming services want to use exclusive contracts to license unique content so that they can differentiate from their competitors, attract new subscribers, and increase profitability. However, consumers often complain about the rising streaming cost, partly because we need so many subscriptions at the same time to access all the exclusive content we want. The other important but often understudied force is that studios often want to restrict the contracts to be exclusive so that they can play streaming services off against each other to negotiate more favorable deals. And here is an example. Amazon and Netflix had a bidding war for a recent movie called Crime 101. During negotiations, what the studio did was to bring Netflix's bid to Amazon Prime and ask if Amazon was willing to pay more for this exclusive deal. And in the end, Amazon outbid Netflix with $100 million. As a result of similar practices, hefty licensing deals are very common in this market. Studios may gain from these hefty fees, but smaller platforms often complain not about these hefty fees, but also about the difficulty to compete with streaming giants in these bidding wars. So in this paper, I study who gains and who loses from these exclusive contracts. And to answer this question, I developed an estimated structural model that captures both forces. The model incorporates consumer demand for titles and subscriptions, platform price setting, and contract negotiations between studios and streaming platforms. And the model estimation is feasible because I collected many new highly detailed data sets from various sources. And using the model and estimates, I quantify the impact of exclusive contracts by studying a counterfactual without these exclusive contracts. And I find that the controversies previously discussed cannot be fully reconciled. In particular, small streaming services that lack in-house content and small studios with weak bargaining power actually gains from exclusive contracts, while the larger ones mostly lose. Consumers also lose due to both reduced title distribution and higher subscription prices. And now let me introduce a stylized model to highlight the key forces behind the rise of these exclusive contracts. Let's consider a scenario with only one studio, Paramount, licensing one title, Criminal Minds, to a network. This distribution network can be Netflix only, Hulu only, or both. Paramount makes this distribution choice to maximize their license fees, which in turn is negotiated with the streaming platforms based upon additional sales profits these streaming platforms can generate from licensing this content. And I assume these sales profits to follow the numbers below the streaming service logos. Here, they're just hypothetical examples, but after this stylus model, I will have a full model to quantify these numbers. I adopt the Nash with threat of replacement solution to determine these fees. When Paramount decides to license to both Netflix and Hulu, it can acquire a share of both services' sales profits proportional to its bargaining power, which is assumed to be 0.5 here. This means Paramount can get half of the sales profits for both services, which generates a total profit of 8. Notice here, these fees are the same as in the standard Nash and Nash solution. Alternatively, Paramount can commit to exclusive distribution, possibly through exclusive contract. In this case, Paramount can still go directly to its licensee and split the profit following Nash and Nash. Or it can use Hulu as a threat to negotiate an offer of 7 from Netflix. Here is how this threat works in practice. Studios often go back and forth between different platforms to ask which one is willing to pay more. For instance, it can go to Netflix first, split the profit in half, and get 6. This offer from Netflix can be then used as a threat against Hulu to squeeze Hulu to pay over 6. And this Hulu's new offer can again be used as a threat to squeeze Netflix to pay even more. Paramount can go back and forth between Netflix and Hulu like this until Netflix is willing to make an offer of 7 so that Hulu cannot outbid. And in short, this model captures the ability for these studios to commit to exclusive distribution and create the scarcity in licensing right. And then induce Hulu and Netflix to compete for this scarcity by going back and forth so that Paramount can negotiate a better deal. Notice here, an exclusive deal with Hulu is not an option because Hulu is only willing to pay up to 7, but Netflix is always willing to pay. And as the owner of the title, Paramount will choose to distribute to both Netflix and Hulu to maximize its profit. Now let's consider 2 other scenarios where exclusive distribution will arise. Suppose now going exclusive can generate much higher sales profits than in the previous example. And this can happen, for instance, when almost everyone in the market already has access to either Netflix or Hulu. In this case, if Criminal Minds is added to both streaming services, no one will add any subscription to her basket because she can already access the content through her existing subscription. So in this case, it will be more profitable for Paramount to distribute to only Netflix and differentiate Netflix so that it can generate a larger pie to be divided by inducing current Hulu subscribers to either switch to Netflix or to multi-home on both streaming services. And bargaining is another important force behind the exclusive contracts. Suppose now the studio is not Paramount, it's A24, a smaller studio. So I assume its bargaining power to be 0.25 here instead. I also reinstall the profitability of exclusive distribution as in the first example. Here, even though distributing to both Netflix and Hulu together can generate a larger pie to be divided, a higher joint profit, exclusive distribution will still rise. And this is because with this weak bargaining power, A24 can only get a small slice from this large pie. Instead, it's more profitable for A24 to commit to exclusive distribution, induce Netflix and Hulu to compete for this exclusive right, and then negotiate a better deal from Netflix alone. Without exclusive contracts, however, A24 will always have the incentive to further reach out to Hulu after reaching out an agreement with Netflix, making, in this case, an exclusive distribution no longer stable. Altogether, the stylus model suggests that studios often want to use exclusive contracts to negotiate better deals, either by creating a larger pie to be divided, as in the second example, or to use these contracts as bargaining leverage to extract a larger slice from a potentially smaller pie, as in the last example. Also, the last example suggests that studios with weaker bargaining powers are more inclined to use exclusive contracts to improve their bargaining leverage. And data shows support for this inverse relationship. I find that the big five studios, which produce about half the content in this market, and are generally perceived to have stronger bargaining power, are about 4 percentage points less likely to use distribution. Considering that only 13% of the titles are distributed to only one platform. It suggests that there may be some substantial differences in the contracting strategies among these different studios. Now, I will give you a helicopter view of my main model. It has 3 stages. In the first stage, streaming services negotiate contracts with studios and then set subscription prices at the same time. In the second and third stages, consumers make subscription and viewership choices respectively. Okay. On the demand side, I use a random coefficient logit model for individual title choices, where consumers have demographic-specific genre preferences. And then, before viewership, each household decide which set of streaming services to subscribe to, considering the title preferences of all household members. And importantly, my model allows for consumer multi-homing across different streaming services. And this model can be identified because I observe market shares for each unique combination of streaming services. So for instance, the share of households with subscriptions to Netflix and Hulu, but not Disney Plus or Prime Video. And using this model, I find that the mean own price elasticity of this streaming services is about -1.4. On the supply side, I have a model where streaming services set uniform prices across time and geographic markets. And using the pricing model, as well as the demand model, I can then quantify how much variable profit the streaming platforms can gain from licensing the title. In the contracting stage, streaming services negotiate licensing contract with studios to split these gains. This is where the stylized model kicks in. And I identify this model leveraging the variation in distribution networks across different studios. That weaker studios with weaker bargaining power are more likely to use exclusive distribution. Using this strategy, I do find that the smaller studios exhibit a much weaker bargaining power compared to the big five studios. Using the model and estimates, I then go on to quantify the impact of exclusive contracts by studying a counterfactual without these contracts. I find on the streaming service side, I find that small streaming services, such as Hulu, gain substantially from exclusive contracts. This is because they don't have much in-house content and therefore rely on licensing exclusive titles from external studios for differentiation. In contrast, the streaming giants like Netflix and Prime Video see minimal or negative impacts. This is because they already have extensive in-house content, so the additional benefit from differentiation using external content is not that substantial for them. And now, instead, they face increased competition from these smaller studios who use their newly licensed exclusive content to attract subscribers away from them and reduce their profitability. On the studio side, I find that the big five studios face lose while the small studios gain. Actually, both groups here face a negative equilibrium effect that I didn't introduce into the balance model due to its complexity, and it works as following. With exclusive contracts, all these platforms have a substantial exclusive content, meaning that these platforms have a lot of loyal subscribers. And with loyal subscribers, these platforms now fear less about losing subscribers after dropping the title. And this reduction in fear brings down the streaming platforms' willingness to pay for content. However, small studios can overcome this negative equilibrium effect because now with exclusive contracts, they can more effectively exert the threat of replacement and extract a larger slice from a potentially smaller pie, and see an overall gain. However, these bigger studios, given their strong bargaining power, can always extract most of the pie with or without exclusive contracts. So they don't get much from this improved bargaining leverage and see an overall loss. And I also find that consumers on average lose about $24 per year due to both reduced title distribution and higher subscription prices. Just to quickly conclude, in this paper, I quantify the impact of exclusive contracts in the video streaming market. And I find that exclusive contracts benefit smaller streaming services and smaller studios, while the larger ones mostly lose. Consumers also lose. And in the slide that I didn't present, I also find that this loss is likely to persist, even if smaller studios significantly increase their content production.
And thanks for having me. Should I wait? So I guess I have 5 minutes. So I'll try to summarize the paper in 30 seconds. I think Yihao did a pretty good job. So hopefully that won't be new. I had 2 main comments. One, which I thought is not very constructive for the paper, but might be useful for the discussion for this audience, kind of thinking about it from, suppose he's presenting in the court in the context of, a Netflix merger that is trying to kind of say something about exclusive versus non-exclusive. What would the judge or the other side will say, and try to kind of tee up the discussion. It's not going to be that operational for the paper, but something for everybody to think about. And my second comment is maybe less for the audience and more for him about like how can we kind of make the paper a bit clearer. Then I have a bunch of small comments that I guess I'll run out of time before I get to them. So what the paper is doing. So just in 30 seconds, the basic exercise is I have to say it's a really impressive paper. Sort of it's a lot of kind of modeling choices and data sources across a bunch of places that is putting together in a kind of state-of-the-art way. And basically the model has like 3 stages. It's basically a decision of what to watch. Then you build it up to the decision of which streamer to subscribe to. Could be more than one. And then the higher level is sort of a studio streaming service kind of bargaining, which is using the Hohenli type of Nash way to kind of model and then the question would be like, do we bargain over kind of giving you my TV series as an exclusive deal versus not? So that's the kind of thing that key to the model. And then the counterfactual exercise, which is kind of the key to the applied portion of the paper, is now let's take all these estimates and then turn off the ability to negotiate an exclusive deal. So kind of if we negotiate the price that we know it's not exclusive because exclusive deals are not, or exclusive content is not allowed. So then we are going to run counterfactual and see what happens. So that's the basic exercise. So we are just turning off and on sort of the ability to kind of negotiate exclusive deals. We are holding kind of the ownership fixed. So if you think about the Netflix Warner kind of potential merger, at some level, if exclusivity is not a thing, but a big reason, not the only reason, but the big reason for the potential kind of deal is that the library of Warner. So if we cannot have the content exclusive, at some level, a lot of the M&A in this area is going to completely change, because a lot of the M&A activity here is about getting the kind of access to libraries and stuff like that. So we are leaving this aside. We are holding sort of for all the paper, kind of all the ownership fixed. And then just ask, how things are changing in terms of like the consumer welfare, the studio's revenues, and big versus small streamers. My main comment, the one that I said is going to maybe tee up discussion and not going to be very constructive to the paper, is the following. So if we trust, and I think there's many good reasons to trust the estimation and data part, so sort of a lot of good moving parts, a lot of sensible identification arguments. Let's give the paper kind of that sort of they got the right estimates with approximately the right model. The key question is like, is it the right counterfactual? And what I mean by that is that once we turn off exclusive deals off the table and we say, well, we are not allowing exclusive deals, in the counterfactual in the paper, basically what happens is that all the rest of the structure stays the same, and now we negotiate as a nash kind of bargaining without the ability to kind of cut exclusive deals. So we are negotiating like a flat price kind of deal. Do you take my TV series or not? Knowing that sort of maybe if kind of Hulu takes it, tomorrow Netflix can come by and kind of takes it too, because we cannot make it exclusive. And this is where maybe then applied theories for a second, kind of, I would think, I'm not sure we can think of this counterfactual world as what will happen once we take exclusive deals off the table. And because presumably if I'm a studio, you took for me sort of the ability to make it exclusive and maybe get more rents out of it. I'll do something else that is legal, kind of, you know, without exclusive deals to kind of make up for the inability to do exclusive deals. And one thing would be like, maybe I kind of write nonlinear prices. Maybe prices kind of are not like a flat price, but basically a function of viewership and stuff like that. The alternative is that maybe sort of if I'm Netflix, I let Hulu take Hulu is the smaller stream, you know, I let them kind of pick everything, and whatever works, I grab and I get all the viewership through me because I have many more subscribers. So then suddenly Hulu is out of business because basically every time they're successful, Netflix is taking all the viewership, so they're stuck with the things that don't work. And it made me think about the software industry, the office software industry in the early 90s, where kind of a lot of new innovators came up with the first word processors and spreadsheets, and then Microsoft and others kind of took up because you couldn't kind of IP kind of the software. So a lot of stuff will change without exclusive deals. So we want to think about it again, probably not within this paper, but if you think about how seriously should we take this kind of factor, or how much a judge is going to kind of buy this. My second comment, which is more to the paper, it's really impressive paper, as I said. It has multiple moving parts, they're all kind of connected to each other. But you come out of it feeling, I wish I understood a little bit better stuff, what is the black box doing. And I'm not totally sure how to do it because it's complicated, but just to pick an example, like this 10% decline in kind of consumer kind of, you know, surplus out of kind of not allowing exclusive deals. That's like the bottom line number. I would love to kind of understand better what parameters are driving it, or what type of patterns in the data are driving this, or how the data should have looked for me to get the opposite result. So it's a typical comment on many kind of heavy structural papers, but I think in this one, like, it's such an important sort of, you know, question and result that sort of you kind of want to kind of build more confidence in terms of not to know if it's right or not, but to understand better what are the driving forces that are driving it. I'll skip the small comments, and that's just like, it's a really nice paper. I'm sure it's going to kind of start like many follow-up papers, and I'm going to see it again next Friday in NBR.io, and we'll have many more than 5 minutes to discuss other stuff. But thanks a lot.
Presenters and discussants, Jennifer Storiali, an associate professor of law at Delaware Law School. Before entering academia, she was an antitrust litigator. Before that, she clerked on the Second Circuit for Judge Robert Katzman. And our discussant is Robin Feldman, the Arthur J. Goldberg Distinguished Professor of Law at UC Law SF. She is founder and director of the UC Law SF Center for Innovation, C4I, the Startup Legal Garage Program, and of the AI Law and Innovation Institute.
Thank you. Hi, okay. So my paper today I'm discussing is called Extra Antitrust. It considers a solution to an antitrust, what I'm going to describe as a problem that is outside of antitrust, and in fact relies on the eminent domain power. So as I'm assuming everyone in this room knows, US antitrust law does not make unlawful the maintenance, the possession of monopoly if it's been acquired by something other than exclusionary conduct. But my argument is that monopoly is bad, and some of the reasons are that it's not only about super competitive profits and reduced output and compromised quality, but it's also because it arms the monopolist with outsized power to engage in things like investing in political campaigns, buying media companies, and engaging in litigation, for example, that is beneficial to them, whether in their own litigation or intervening as a party or writing amicus briefs. But US antitrust law doesn't outlaw the possession of monopoly power unless there's exclusionary conduct. So I looked for solutions. I didn't actually quite look for them, it dawned on me, but the solution I am considering is one from outside of antitrust law, and it's specifically eminent domain. So under the takings clause, property can be taken so long as it is for public use and the property owner gets just compensation. Under the Supreme Court's jurisprudence, though, the public use requirement is a really, really low bar. It does not require that the property be taken and used by the public in the way that a street or a park or a courthouse is. It merely has to serve some public service. And so there are a number of Supreme Court cases that consider this, but the one that I really unpack and rely on in the paper is a case called Hawaii Housing Authority versus MidCIF. And in that case, the Supreme Court found that the taking of property from indigenous Hawaiian for a trust created for their benefit served the satisfied the public use requirement because taking it, and this is where my antitrust spider senses went off, corrected an oligopoly in land. And so the idea was that under the Hawaii Housing Hawaii Land Reform Act, the HLRA, under the HLRA, the tenants on the property were permitted to petition the Hawaii Housing Authority and ask for a hearing. And then they would hold a hearing to see if condemning the property would actually serve the purpose of dissipating this oligopoly of land. And then if it did, they would condemn the property and then it would be sold. And there was a number of different people who could potentially buy, but the first comers were supposed to be the actual tenants on the property. So the law, the HLRA, effectuated a taking of property from the property owner and transferred it ultimately to the tenant. And this, the Supreme Court concluded, served the public use function, the public use requirement takings clause. So my paper, I frame it as a thought experiment. And the idea is like, how far can we actually push this holding? And I originally contemplated using it in the context of intellectual property rights. The idea was you could take licenses to intellectual property and give them a compulsory license to correct monopolized markets, for example, platforms. There's a number of gnarly issues dealing with IP, which Professor Feldman is well aware of, which include are patents property for purposes of the takings clause. And so I have sort of put that to the side for the moment and just dealing with it in the context of the real property. And the illustrative example I marched through in the paper is contemplation of the market for dialysis treatment centers. So as many of you know, the market for dialysis treatment centers is highly concentrated. It is mostly constituted of two firms, Fresenius and DaVita. Because of the nature of those markets, consumers don't like to travel more than 25 miles from their home is the latest data that I saw. And so there's many local markets. And so the idea is that a state, we're in California, the state of California could have a hearing, decide that the market for dialysis treatment centers is highly concentrated, pass such legislation, and enable would-be competitors to DaVita or Fresenius to seek a hearing. And if they found that exercising eminent domain would actually correct this monopoly, then we could condemn the property and allow it to be purchased, and it could be purchased by a potential, a would-be competitor. There are challenges with this model, this thought experiment that I have constructed. One is that a successful business is not just constituted of the real property on which its businesses exist. There are other things like, excuse me, know-how, employees, intellectual property rights, even in a real property business. And those are all things that would have to be contemplated and would have to be navigated in order to make doing this successful. But it's the kind of things that the Federal Trade Commission and Department of Justice consider when they have to decide about a divestiture. There's also the fair market value. How do we actually calculate fair market value for such a property owner? One reasonable way of calculating fair market value includes lost profits. And so then we have to navigate the question as to, do we want to compensate the monopolist for their lost monopoly profits, or just some sort of something short of that, something reasonable? It's a little less compelling, I think, in the real property context, but in the IP context, I contemplate using monopoly profits, and the rationale being that when you have a monopolist that is difficult to dislodge, like a platform, because there's network effects, then it might actually make sense to compensate them for monopoly profits, because it's very hard to dislodge them, and we're not compromising the incentives that they had in the first place to innovate. And then there's Supreme Court precedent piece called Armstrong, which provides the rationale for why do we have just compensation in the first place. And the idea is the reason why we have just compensation is because we don't want any one property owner to have to bear the cost of some sort of societal good. So if we think that if you want to thread the needle between what we have as these sort of antitrust ideals and then yet and then a competitive market, we want to hold up the idea that we want to reward the monopolist, but yet we actually like competition. One way of doing that is to compensate the monopolist for their monopoly profits by allowing there to be competition and creating a competitive market. The last thing I'll note, and I don't know where I am on time, but yeah, 8 minutes. Oh, I'm doing great. So more for Professor Coleman to comment, is the Commerce Clause. And so the Commerce Clause is not my expertise. It's not any of yours, I'm assuming, either. So I'm not going to worry about it too much, but I have to still navigate sort of worries that the Commerce Clause might present in terms of having a state legislate an area that is also legislated by the federal government. And that's it for me. Thank you.
Thank you very much. It's an intensely creative proposal, one that doesn't exist anywhere in the literature, which makes it fun to contemplate. I also admire the way it holds the Supreme Court's feet to the fire. If the justices are going to use such broad language about what public use means, then they have to live by it, particularly those who vigorously defend the sometimes amorphous notion of what a state's police power is. That is, how broadly can a state act? One challenge for the proposal is the idiosyncratic nature of the Supreme Court cases on which the proposal rests. So if you look at that Midkiff case, that's the one that was the Hawaii land system that was broken up by the state of Hawaii, blessed by the Supreme Court. Although benevolent in its intent and indigenous in its history, that Hawaii land structure likely looked to the Supreme Court like a version of feudal England in which tenants would work the land for their entire life and never be able to have ownership. That's fundamentally antithetical to the American system of property and free ownership. So that likely and appeared to animate a lot of what was happening in that case. Another case that gets discussion here is the Ruckelshaus. This is a case with the Environmental Protection Agency and safety data that was claimed as a trade secret. I don't actually think it was a trade secret, as someone who studied trade secret, but that's a different question. However, when we have a circumstance where government is granting approval, particularly in the context of safety, approval is often thought of as a government benefit and access. Courts give the government greater latitude to put restrictions on what they are doing. So if you're using those two cases as the foundation, sort of wondering whether the courts, particularly the Supreme Court, will be willing to give states that much latitude outside of such idiosyncratic areas. Commerce Clause, I have unfortunately spent a lot of sleepless nights thinking and writing about Commerce Clause. That is the notion, for those who aren't lawyers, that's a notion that a state cannot regulate outside its borders because that might interfere with interstate commerce. And the problem for the proposal is that the courts have rarely seen a market that they consider to exist only within a state. Even if all of the activity happens within the state, courts have a marvelous tendency of finding impacts outside the state, and that's going to make it difficult. I do think one of the real problems is the one that the author so rightly pointed out, which is transferring real property won't break monopoly power in most of these markets. You've got human capital, intellectual property, and these are the same challenges that the FTC and the DOJ have encountered in divestiture cases. We got two problems. One is that they clearly do have the right in those cases to require the transfer of intellectual property and divestiture of complete divisions. So they've got power that the states probably don't have. In addition, if you look back across time at the FTC and the DOJ's track records, when they have asked for divestiture, and then look back to see whether it actually has created long-term real competition, their track record's terrible. So they've got a lot more power and they've done poorly. So weary whether the states are going to be able to manage this. I know we're putting aside intellectual property. I won't belabor that point. There are serious problems if you start by saying, well, this is going to be a problem if I can't include intellectual property. Intellectual property is going to be a real problem because there are problems applying the takings clause to anything in the intellectual property clause of the Constitution, like patents. And particularly, Justice Thomas has waxed poetic about the fact that from an original interpretation perspective, such rights in the intellectual property clause, like patents, are not private property rights, but they are akin to government grants, so they're not subject to takings. I think the greatest challenge for the proposal, and the one to grapple with, is that it rubs up against the limits of what governments do and what they can do. That is, what's the limit of states' power? Now, I'm going to be the first to agree that this notion of the limits of states' power is not consistent and not consistently applied, but there is an undercurrent. There's a through line that frames the state's police power in terms of, and this is a quote that comes up, long-standing notions of what government traditionally does. From that perspective, the innovative nature of the proposal could be both its blessing and its curse. It is so innovative that it's not what government and what states normally do. It's going to be hard to get the Supreme Court to look at it without blinking. There are a couple of small areas that I think could strengthen the points as you flesh out the draft. Many of the examples in the intro paragraph speak of increased concentration in various industries, but they don't take the next step of showing that concentration has increased to a dangerous level or to a level at which that would justify this proposal. So maybe those markets are more concentrated, but they're still dynamic and competitive. We have a small number of people in various levels of the AI markets, but they are vigorously competing with each other. It can't be that any increase in concentration warrants taking people's core private properties. You got to come up with something that you identify as a reason to act, and then draw the lines to show that that's where we are. And finally, I kept wondering throughout whether this might be using a howitzer when a scalpel is what's needed. So if I looked at the antitrust problems that you described so beautifully, and I kept wanting to nod all the way through and say, yes, 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 is it the problem that the antitrust doctrines are interpreted too narrowly? Or that the negative impacts of ancillary behavior aren't properly recognized in antitrust law, or behavior reinforcing monopoly isn't accounted for, or markets get defined too narrowly because of we don't take account of network and reinforcement effects. All of those could be the scalpels. The problem with using a howitzer is that it can obliterate the surrounding landscape. You can do a lot of damage in the process. So what can you add to the paper, to the proposal, that reassures readers and policymakers that it won't just take a machete to private property and private industry? And those kinds of breaks will be important. I'll close with preemption, another favorite of mine. You will get challenges on preemption. It'll be in the conflict preemption type. Preemption is the notion that federal antitrust law preempts what you're trying to do with the state takings. So within conflict preemption, there are two branches. One is obstacle preemption. You're lucky on that because Justice Thomas has said very explicitly, he doesn't believe that obstacle preemption is actually a legitimate way to block what a state wants to do. So you're gonna have some help on your side. And although I think it'll probably fail, you're going to invite the dreaded impossibility preemption charge. I think it would be framed something like this. If antitrust law presupposes certain fundamental market notions, for example, that concentration alone is not bad. Big is not bad, it's what you do with your size. So if that's a core concept of the antitrust laws, perhaps this proposal would obliterate that core concept in a way that makes it impossible for federal antitrust to operate. So I recommend including a rebuttal to that because I think you can do that. In any event, thank you for letting me read this interesting paper, and I look forward to seeing how it develops.
Thank you very much. Let's welcome to the dais our next set of presenters and discussants. Maria Macia is an economist and an associate professor of law at Notre Dame Law School. Before Notre Dame, she clerked for Judge Andrew Hurwitz of the Ninth Circuit and also worked as an economic consultant and high school teacher prior to law school. Our third discussant is Danny Sokol, Franklin Chair in Law and a professor of law and business here at the USC School of Law and Marshall School of Business. Professor Sokol serves as faculty director of the Center for Transnational Law and Business and is the co-director of the USC Marshall Initiative on Digital Competition.
Great. Okay, so this is a paper, it's very much a law paper. I have one regression in it that I'm going to talk about, but this paper is in desperate need of examples. So I think many of you in the audience will have examples that will help flesh it out. So I think antitrust has an economics problem. Antitrust cases have become increasingly economically complex. Just, you know, the addition of tech has made industries more complex. You add network effects, you add platforms, and sort of some of the simple intuitions that judges could have used when they were muddling through economic reports just don't get them as far as they need to. So in 2006, and this problem has increased since then, the ABA task force did a survey of 42 antitrust economists, and only 24 of them believed that judges usually understand the economic issues in a case. So this leads to situations in which judges either actively avoid the economic analysis or make mistakes in trying to engage with it. So I'll give you like 2 examples of this. So this is ignoring economics. So Judge Hurwitz, who, as you just heard, I clerked for, I think he is probably the smartest person I have ever met. Very sophisticated, took antitrust with work in law school. So here's an example of a case antitrust case he worked on, St. Alphonsus Medical Center. So in this case, he declined to like consider efficiencies in that case. And this was what he said about it. We remain skeptical about the efficiencies defense in general and about its scope in particular. It is difficult enough in Section 7 cases to predict whether a merger will have future anti-competitive effects without also adding to the judicial balance a prediction of future efficiencies. And then he quoted Frank Easterbrook from Limits of Antitrust. Neither judges nor juries are particularly good at handling complex economic arguments. So here's an example of a judge thinking about his limitations and saying the fact that judges are not good at economics means that the right way to approach this case is to simply not consider an efficiencies analysis. Here's an example of a judge trying to engage with the economics, just a case where I think it was sort of unavoidable to do it, and trying to work with the models, and then ends up really tripping up. So this is Judge Leon in the United States versus AT&T case. So I teach this in my antitrust class. This is my least favorite class because it's just so complicated that I know the students will be very confused by it. And this judge was confused by it as well. So this is a Nash bargaining model where there's sort of an outside option that's relevant. So the outside option is a blackout. And the idea is like if you consider the diversion in the blackout situation, it's going to be more profitable after the merger. That's the idea. So Judge Leon looks at this and looks at the depositions with the executives, and he thinks that the blackout is not going to occur. Therefore, this model needs to be thrown out. So he's thinking about like the assumptions of the model, but he just doesn't understand the economics of it. So, and completely misinterprets it. On appeal, the appellate judges realized that they went on, but but because this is not clearly erroneous, there were other facts that supported what Judge Leon did, and so, these are two examples in which I think judges were not getting the best antitrust outcomes that we could, and it's due to sort of judges not having enough of an economics background. So this paper is sort of asking whether experience, which we would facilitate through a specialized court, would help address this problem. So if the judges in question had had more experience with economic cases through seeing more antitrust cases, would they have been more willing to consider efficiencies, or would they have avoided that mistake? So that's the counterfactual I'm asking you to imagine. So I think that specialization leads to judges being more economically experienced through two channels. First of all, there's a selection effect. If you tell a judge that you are only going to be working on antitrust cases, this changes who wants to be a judge, and it also changes who we're going to appoint to be judges. So you'll have more economically sophisticated judges starting out from the beginning. And then there's also this idea that they're going to have the chance to learn. I'll just talk a little bit about, Joshua Wright and Michael Bay have studied the impacts of the Manning Institute. And so in the Manning Institute, giving judges economic training seemed to help them with the simple antitrust cases, but it didn't help them with the complex antitrust cases. So I think there really is sort of this learning by doing that's necessary, of seeing it applied, sifting through the economic expert reports that's really necessary. And that sort of learning requires hearing multiple cases. So the paper is asking whether it's time for a specialized antitrust court so judges can gain economic skills from the repeat exposure that specialization provides. The reasons why I think it's important to ask this is we do see specialization helping in other areas of law. So there's literature that shows that in criminal law cases, if you as a judge hears more, so criminal law, often we do see specialized courts in different states and countries. So as judges hear more cases, you see between judge disparities going down, which is great from a justice perspective. And judges are more likely to use shortened procedures effectively, which is also good for the defendants to get decisions sooner rather than later. In the bankruptcy context, if you look at judges who have been on the bench longer, and again in the United States we have specialized bankruptcy courts, they spend, if you're a newer judge, you spend more time on the cases, and you have lower creditor recovery rates, and there's a lower return on assets post bankruptcy. So there's this idea that having more cases is going to help them be more effective. And then you can see similar results in the patent context as well. So in the antitrust context, I would say this is an underexamined area. So there's one empirical article on this, also by Joshua Wright and Angela Diatley. And so they look at whether agencies outperform generalist judges. And the idea is that if you look at sort of what's happening at the FTC, the courts within the FTC, the administrative law courts, that is a specialist court, and the question is whether that does better than district court judges. And the way they evaluate this is we look at appeal rate, what happens, whether the parties appeal more. The idea is if you get the decision right, you're less likely to appeal. And they find that the appeal rates are not different between the two, which would imply that the specialist court isn't doing any better. But I think there's a flaw in the way that this is set up, which is that if you're talking about appeals from the administrative law courts, those parties get a choice of where they're going to appeal. And so because you get to choose your venue for appeal, you get to choose a more favorable venue. So that makes the benefits of appealing higher. And so we wouldn't expect to see a higher appeal rate from it. So like your expected higher appeal rate is different starting out with these groups. And so the fact that it's the same could actually reflect that the administrative law judges are doing better. So I would call that study inconclusive, and I think there's a need for further study in this area. So the contribution of this paper is to sort of summarize a little bit some of the literature on specialization and think about that sort of with our new problems in antitrust. And then I'm also documenting how little learning happens through recent repeat exposures and antitrust cases. So no papers show just how rare it is for a district court judge to hear multiple antitrust cases in the US. And then I'm using Chile as an example as a way to learn. So they have a specialist antitrust tribunal in Chile, and I'm going to be testing for learning as the judges hear more and more cases there. And then I also talk about why economic analysis will make antitrust adjudication better. And I have like some practical ideas for how we might set up a specialized court here. Okay, briefly covering the cost. I've already talked about like what I think the main benefit of specialization here. So the cost we should be aware of. There's some evidence that circuit splits, create opportunities for learning when the Supreme Court is hearing things. Not as much of an issue in antitrust. If you look at antitrust cases, it's very rare that get to the Supreme Court. It's rare that there's a circuit split. Judges might draw connections from other areas of law. I think that sometimes we actually might want to encourage more tunnel vision in antitrust. There's pressure to expand consumer welfare, and that might not be a good thing. The specialization might lead to hubris. It might mess with our sort of error cost analysis. So I think that that's less of a risk in antitrust because judges are already like error cost is so much part of antitrust analysis that I think judges are already thinking about their own potential for errors. Inefficiency in caseload management. The proposal I'm going to provide would actually lead to more judges. And so hopefully this would not put a strain on it. And there's some flexibility built in, so you wouldn't see inefficiency problems. And then the potential for capture. So this is, I think, the biggest issue to think about. And sort of this comes from, if you look at the patent, the specialized patent court, there does seem to be evidence that there is capture there. So when I get to the proposal, I think that that's going to be something that's important, like thinking about how we can set this up in a way that we're not going to cause regulatory capture problems. Okay, so this is empirical contribution 1, which is just showing how rare it is for a district court judge to get a chance to learn hearing multiple antitrust cases. So right now, this is the Ninth Circuit. I'm planning on expanding this beyond that. So but in the Ninth Circuit, I went through and I coded all the substantive antitrust cases since 2000. And I was looking at, I think it's actually 1990. I've coded all of them since 1990. And I'm looking at how often a judge hears a case more than once. And and this is the judges and the number the number of cases that a judge hears that involve antitrust analysis. So this is by the number of the number of judges in the time period. So 75% don't hear a case at all. And if you're talking about judges that hear more than 5 or more cases, it's less than 3%. So if we think that you need 5 or more cases to learn, less than 3% of judges are getting that learning experience. And that also means that less than 3% of antitrust cases are benefiting from that learning having. So contrast that with the TDLC, the Tribunal de Defensa de Libre Competencia in Chile. So for this, the judges, if you look at how many judges hear less than 11 cases, it's 26%. And you have more than 23, it's about 23% who hear more than 100 cases. And because they sit on panels, that basically guarantees you're going to have an incredibly experienced judge sitting on the panel and hearing the cases. So, just a few facts about the TDLC. So some people might say Chile is a small country. What can we learn about it from the United States? In the United States, where we have a much larger economy, antitrust is an important issue among Chileans. In a smaller economy where the degree to which people know each other is high, you actually end up with a greater risk of antitrust violations. So it's very interesting in Chile, teaching employees about antitrust problems is considered part of corporate social responsibility. So where you and I might have sexual harassment as part of our training as employees, in Chile it's very common for employees to learn about antitrust and because it's such a big issue in a more interconnected economy. The antitrust decisions are relatively similar to US antitrust doctrines. And you have this court where it's sort of an independent court, and it was set up because there was a need to have expertise as the economy became more complex. So the first thing that we can see with the TDLC is just this benefit I was talking about with selection. Simply by setting up the specialist antitrust court, they doubled the number of judges who had economic sophistication and experience in competition law, when they were hearing cases, which I think is a huge impact alone. I have a regression where I'm looking at the effect of learning, and let's get straight to the to my model. And what I find is that that there's a statistically significant effect with judicial experience. So if you sum up the number of cases that the different judges are hearing, have heard up to that point, you find that this increases the number of economic terms that they hear and that they use in their decision. And I find that this sort of goes up by about 1/3 compared to the average. So you can, in this according to this regression, the economic sophistication raises the number of economic terms by 1/3 simply by having a specialized court. So I think that this helps antitrust law in several ways. So if we can make judges more economically sophisticated, it's sort of this response to concerns that judges are making errors and we need to put more rules in a per se category. And that's going to be good from an efficiency perspective, because we're going to avoid some of the overbreadth problems of per se categories. And related to that, it allows for continued movement into a rule of reason realm. It also allows for more use of efficiencies analysis. And I think this also helps with our debates about consumer welfare. So there's concern that the consumer welfare standard has led to under enforcement. And the idea is that if we can have more complicated models that judges are going to think about, then we can broaden our idea of consumer welfare to include quality, for example, and more complicated models of effects on consumers that currently are too difficult for judges to think about. So I think this makes the consumer welfare standard more stable. And then I would love to have more examples of errors that judges have made, and I could show how economic analysis would help with that. And then I'll just close with talking about what the court would look like. So I think the best model is a foreign intelligence surveillance court, and this has borrowed judges to deal with sort of surveillance issues. And so we could do that with antitrust. Judges could be normal district court judges, but they would also sit on this specialized antitrust court for a period of some number of years, maybe 6 years. And then the review court would also be borrowed appellate judges as well. And this lowers the probability of capture because they're not going to, there won't be a revolving door going back into industry. And I think it also deals with some of the tunnel vision ideas. They're going to bring in expertise in judging.
Danny, 5 minutes or less.
Sure. There's a lot to like about this paper. I think there were slides I have, but I don't need them if we can't get them up. So what does the paper do well? I think it provides a counterfactual of what a specialized court looks like. I'm glad we actually have this slide up right now, because what we have in Chile in terms of structure is very different than the kind of structure you suggest. So very quickly, Chile has 5 judges of the tribunal. 3 of them have to be lawyers. 2 of them are economists or ingenieros. And I use that term because it's largely MBAs or equivalent, because, for example, at the Universidad de Chile, the business school is actually in the engineering school, as Jonathan knows because he presented there just 2 years ago. My colleague, John, amazing. But I want to actually talk about somebody else who's amazing, and they're sitting right next to me. So Maria's paper, I think, is very important, but it also begs a broader question of what is it we're measuring? And how do we think about antitrust learning? Is it the quality of the analysis? So then, even if we're using economic analysis, are we actually deploying it the right way? We might actually think about whether or not we're using the economic analysis maybe the way Judge Leon did. And for those of you who are familiar with that decision, literally 49 exclamation points. Judge Leon is an interesting figure. And the question is, I mean, there was discussion of Nash bargaining models, right? You'd say, oh my God, this is great. But is it actually great? So we might want to introduce sentiment analysis, but since you're looking at Chile, it would be sentiment. And we might look to citations of the economic literature. We might actually think whether these citations are actually relevant. Like, it's really great that they're citing to a seminal paper written in the 1970s, but actually the literature's progressed quite a bit since then. Do they really know what's going on? How are they thinking about the stylized models? How are they thinking about the empirics? Do we cite to economic experts? For example, I have a paper on that. So she already cites to it, so that's what matters. But we might think are we thinking about judges telling a story? And the economic analysis is just another way, and the expert is a storyteller. So some of you are old enough to remember there was VH1 storytellers 20 years ago. You'd have bands, artists talking about how their song came into being, then they'd play it, and it was great. And back then, that was before streaming. So we can say Andres is a storyteller. That's what he does. He uses pictures, he uses numbers, he uses words. Belinda is also a storyteller. If we think, for example, to Economics Day in the Amazon case, it was two lawyers doing the economic analysis for the judge. They were the storytellers, not the economists. So we wonder from that perspective how we should be doing the storytelling, who should be doing the storytelling, how we measure. Is it that they're using specific economics terms, and this is the Day and Wright paper? Or we might imagine a world where the judges actually use formal modeling and equations in their decisions. We've seen that before. My favorite was district court case to enjoin the merger of Oracle and PeopleSoft, where we got a demand curve in the footnotes. Was it a better decision? It was a 103-page decision, which meant basically it was unappealable. So we might think about that. Now we get to the interesting questions like, what are the equivalents? Do we think about, say, the federal circuit, right? So it turns out it's a very mixed issue there. And I wonder, one thing to look at are coalitions as between the economics who are the economists who are the judges versus the lawyers who are judges, and how the coalition works. How important is the head of the court as in terms of building this coalition? And then sort of a broader question on this, which is, do we capture the full set of costs? What if we get uniformity in rules, but it's actually the wrong rules, which was actually the US experience for a long, long time with per se rules that made a lot of things illegal that shouldn't have been. And the question is, even within economic law, do we see differences? So we had two Supreme Courts in France, one that has a contracts court that actually had non-lawyers, and then some that had lawyers doing rights. Do we actually see better decision making? And then finally, how about bankruptcy courts, right? That might be another area where we're looking at very sophisticated work, but it's judges, some of whom have law degrees and maybe economics or finance background, but some of whom don't. So I'd say this is really great, and this is multiple papers, but this is a great first one. Thank you.
Bit of presenters and discussants. Omar Vasquez Duque is an assistant professor at Rutgers Law School, where it's Antitrust, Business Organizations, and Casual Inference in Law. He was previously a law and economics fellow at NYU and held multiple positions at Stanford, including at the Rock Center for Corporate Governance and the Olin Collegiate of Law and Economics. Our discussant is Vivanashu Abhishek, an associate professor of information systems at the School of Business at UC Irvine. His research focuses on the effect of emerging technologies on consumers' behavior, business strategy, and market structure.
Well, hi everyone. Thank you very much for your interest in my paper. Special thanks to Danny and Jennifer for organizing this event. So, well, the paper I'm going to present today is very simple. It's a case study of 3 different related interventions that involve the use of a choice screen. That's a pop-up window that prompted users to do their default applications, either internet browsers or search engines. So there's an example there on the right-hand side of the screen. And we know that the integration between applications and platforms has been a very, very hot topic in competition policy for a while. So the first case, actually the Microsoft case, right, from the mid-90s. And I analyzed the impact of the choice screen that the Europeans mandated Microsoft to display in March 2010. So that's the first intervention. The second one is the Android choice screen from March 2020. And third, the much more recent choice screen from the DMA, the Digital Markets Act. And well, this is the main contribution of the paper because so far there's really no empirical analysis on the effect of the DMA on Google or Chrome's market share. There's just one main idea, and that idea is that forcing people to choose their application doesn't make much difference. Either if the default application is good, like Google, or if the default application is bad, like Internet Explorer. So I think the results show that people are much less passive than what policymakers and enforcers have assumed. Well, just in case this is a positive paper, not normative, I just refer to the impact of choice screens. I don't even think that people should have to engage with them. I believe that if there's an effect, probably it's the least sophisticated users who are sticking to applications that they don't prefer. So why is this important? Well, choice screens have become the dominant remedy to tackle the vertical integration between platforms and applications. That can be the operating system, an internet browser, or the operating system, a search engine, and so on. And this is a European idea that's expanding worldwide. So we see the Australian Competition Authority recently recommended the use of choice screens, and also Trump's DOJ. Okay, I would like to now refer to the first case, and this is the Microsoft choice screen from 2010. So I'm sure we all know about the Microsoft case that it dealt with the operating system, Windows, and the internet browser, Internet Explorer. And while in the US, Microsoft had to commit to provide lots of transparency about its code, in the European Union, well, Microsoft, not surprisingly, paid a record high fine and also was mandated to display this choice screen, which you can see there on the right-hand side. And it showed 13 different options that people could choose from. And well, for over a decade, people just assumed that this had been an impactful and meaningful intervention. So here is a statement from the former Commissioner Vestager from March 2019. So she said, "We've seen in the past that a choice screen can be an effective way to promote user choice." Well, I've studied it for years and I can tell you that there wasn't any evidence to back that claim. So that was great for me. I wrote the first paper of my doctoral dissertation on that. I used data from StatCounter, which has data on internet browser market shares from 2009 onwards, pretty much every country in the world. And when considering different combinations of developed countries and also developing countries, we see pretty much the same thing. The Internet Explorer's market share was going down everywhere, and that's because it was just a bad browser. When we consider different combinations of developed countries comparison group, we can conclude that at most, this choice screen lowered Internet Explorer's market share by 2%. Well, how about the Android choice screen? So this is a more recent paper by De Carolis and co-authors from Bocconi. They found that the Android choice screen didn't have a statistically significant effect on more European countries, with only 2 exceptions. Well, their point estimate was close to 2%, but not statistically significant. And those exceptions were Turkey and Russia. In Turkey, people didn't only see a choice screen. So the competition authority also prohibited Google from paying up. So what happened is that some phone manufacturers, like Huawei, contracted with Yandex, a local search engine from Eastern Europe. to become its default. So there was a change of default, and we know that's actually a much more meaningful intervention. Something similar happened in Turkey. People only got to see 3 options to Russian search engines and Google. Well, I think there's a very strong anti-American sentiment there that explains the result. Okay, so how about the Digital Markets Act? So this is from last year, a regulation that Europeans announced with great fanfare. It's like the GDPR, and not surprisingly, it didn't have much of an effect, or if it did, it was just a hassle for people, like cookie banners. Well, they said with the DMA, we want to make markets more innovative, more open, also more fair. And so they mandated again a choice screen, and it's very important to tell that for Android devices, Google ensured that all the Pixel users would see the choice screen by March 2024. Okay, non-Pixel users probably didn't see anything. That's important. For Apple users, only people who were using Safari as their default browser got to see a choice screen. Okay, so anyone using any other browser didn't see the choice screen, and that's important. So Mozilla actually complains that there's been very substantial non-compliance issues, and I think that's likely. So, well, the data I'm using comes from StatCounter. It's a publicly available data source, open source, so anyone can replicate the analysis. You can also get my data from my GitHub website. And the main difficulty here to measure the impact of the DMA on Google's market share is that there were no parallel trends between the European countries and the rest. So we couldn't use a traditional difference in difference identification strategy. So I use a more involved one that comes from the computer science literature. It's matrix completion, but it's very similar, and basically it builds a synthetic control, and it also infers patterns from the data. It can infer relevant covariates even if they are not coded in the database. So I think what we can see for Google, the y-axis of the plot, the range goes from 95 to 100% because there isn't much variation. So again, there's no parallel trends. In the EU, Google's market share is very stable at first in the comparison group, and that's all the developed countries according to the World Bank. By 2020, we see that Google's market share was actually going up. And there isn't much change. Finally, Google's market share drops in both groups. So when we crunch the numbers and apply this matrix completion estimator, we see a small effect, very, very small. Actually, at first, it's pretty much as large as the prediction error, the pre-treatment period. Then we see a larger effect, and that's still below 1%. So it's a half percentage point. I did run placebo tests. So how about Chrome? Well, here the parallel trends look great. So we could have run a different diff. And well, we see that throughout the whole period, Chrome's market share goes up by 10%. Then, so what did the DMA do? It actually lowered Chrome's market share, but by less than 2%. So it's still a very, very small effect. And well, that's the paper. So I would like to conclude with some questions, food for thought. So first, what's the effectiveness of choice screens? So well, I'm pretty sure that Europeans wanted to lower Google market share because that didn't happen. It wasn't effective. But we also know that Opera's downloads increased quite a bit after the Internet Explorer, or the Microsoft choice screen at least. So it seems that at least some people experimented with other applications. People just kept using whatever they used before, probably because it's just the best. Objectively, that's a search engine. Well, some people say it just doesn't make sense. Like DuckDuckGo, they are pushing really hard for choice screen. They run similar studies with focus groups, and they see, well, this is just poor design. So if we include the descriptions of each option, maybe a nicer logo, people would take them more seriously. However, we just don't see that happens in the real world. The DMA has used different designs. And also, I believe that most people consider these pop-up windows just a nuisance and don't pay attention to them. Importantly, the effects seem to be coming mostly from new Android phones. That's also compatible with the hypothesis that people don't pay attention to choice screens overall, and maybe they pay a bit more of attention when they are setting up a new device. And also, who's the winner? And it isn't super clear. We only see a wealth transfer from Google to Firefox and Opera. DuckDuckGo, you keep pushing hard for this tiny effect that don't make any difference for consumers, but they still make a lot of money from this. And well, we can see that if we actually want to make a difference, forcing people to choose is not an option. However, we see that the change of defaults that can make a huge difference. I don't know if that's socially desirable or not, but this is pretty much what we're preferring. And I think by putting these three interventions together, we can see a trend, and I believe that the results are very robust. That's it. Thank you.
So I found this, if I can get my slides up. So I found this paper very interesting for one very specific reason, that this is a result I hadn't expected. So the narrative is, all of this kind of intervention actually leads to a switching in the market power. And when you actually look at the data, that's not true. So for me, that was very interesting to sort of notice that effect, which was different from what the popular narrative had, right? Even it's been quoted in court cases and whatnot, but I think the narrative, the actual reality is very different. So I think that was very, very interesting for me. And I wanted to use this seminal, Microsoft Windows choice screen, kind of going a little bit retro. And the question really is, I think the important question, I think which will come to the next slide, right? Which is, when we look at digital markets, they're very different than most other markets that we look at. They are typically very concentrated because there is economies of scale in technology. So what the top search engine can do is very, very far superior than what the second search engine can do. So it's almost like a power law effect in terms of how the market concentration works in this case. And as a consequence, the regulators are often concerned about the fact that the monopolists are exploiting their position in the market to, of course, rule out competition, but maybe inadvertently or knowingly actually hurt consumer welfare in the market. And I think there is, in the last couple of years, there has been a lot of narrative on big tech. Europe is really after big tech in many different ways. So this was a very interesting intervention of the DMA and trying to understand what's the impact of DMA on, and the introduction of the choice scene on the behavior, on the choices that people make. So I found the paper to be very technically very nicely done. It's a short paper, but I think quite insightful. But before I get into the empirical results, I think the core of the paper talks about what is driving consumer behavior. And I think this is where a feedback on the paper that the consumer behavior model can probably be improved more significantly. And I'll talk about this a little bit later, because that will help us tease out what is exactly driving this less change in the final outcome. But the two things that we should keep in mind is there is a status quo bias. If I get an iPhone and Safari is my default browser, I'm just going to use, very few people are going to sort of switch from Safari to Chrome or some other kind of browser. Maybe someone like me, like I did not get an iPhone till I could use Google Maps on the iPhone. But there are very few people like me who would be like, I need to have my application working on whatever device that I'm using. So most people like to go with the default, right? And sometimes it might be the rational choice. No, you have a device, you have an OEM that is providing an application. Clearly, that application is going to work better because they know the internal details of how that whole hardware works. Sometimes it can be people can't make choices because they don't know the information. They might have misperceptions about other choices that they have available. Or it can be psychological commitment, right? I've already, for some reason, the switching cost probably is lower in most cases. But let's say if I'm starting to use Internet Explorer, even if it is a bad software, it's a high shift to go to like Google Chrome or Opera or whatever it is, right? So the choice screen fundamentally changes the status quo. When you start working with an application, like when you start working on a device, it forces you to choose one of these things. I think the concern I have is, if you go back to the Microsoft example, most consumers don't know how to choose. And I think there are some really cool papers in marketing that talk about if you give people more than 3 choices, they give up. So choice is good, but choice design is also an important aspect that probably has not been considered. And just giving everyone all the choices is not the right approach, right? So I think, how do you get these choices? How many choices you give? What information do you provide along those choices? Are also important design questions to answer. So I think that would be one direction to think about is there a better design that can improve the effectiveness of these interventions, right? So now getting into the results, right, that Omar mentioned, so I'm not going to belabor the point, but I was really surprised by seeing very, very small effects sizes, given that a lot of these, applications have significant market share, right? So if you have 60, 70, 80% market share and it's dropping only by not even a percentage point, clearly the intervention is not working. But it's important to understand why is it not working. And I think it can be done in a few different ways. One is building a deeper model of consumer behavior and consumer choice so that we can figure out what is the decision-making criteria. Are people just lazy and they don't want to even think about the choice? Is it they can't process the information that is given to them even when the screen, like they have the choice screen in front of them? Or is it something else? Is it like the default is the best alternative and they know that it is the best alternative, right? And then finally, I think something that I was thinking through, I'll just end at this point because I think I'm almost over time, is the switch always going to be between the big competitors, right? Is it going to switch from Safari to Chrome to some version like Bing? Because I think it's very difficult at this point for a new entrant to come in the market and sort of, take over this, let's just search, for example, as a category. So that's sort of one aspect of it. The second aspect of this is, does even that 1% dip allow a room for a new browser to come in? So I think these are questions like I don't know the answers to, but I feel that very strongly we are not moving from an incumbent to an entrant, but we are moving from an incumbent to an incumbent towards an incumbent in a different domain, but has the market power for distribution, right? So I think then it's distribution that becomes key in this setting. And so if that is the case, then the initial hypothesis that DMA has, for example, doesn't work because you're moving from one big tech to another big tech. So I'll just pause there.
Thank you. Part of our panel mirrors our life, in which Andres does all the hard work and he makes me look good. I will turn it over to Andres as our section discussant to wrap us up across all of the
I would disagree with that, but so thank you for letting me participate in this session. 4 very interesting papers, very different papers. So I was trying to find a common thread across them, and I think to me, what the papers do is they explore the challenges in antitrust law and antitrust in economics, especially in digital markets. And digital markets are complicated. The economics is complicated. So I want to make two key points here, and then I'll say a few things about each of the papers. Mindful that I only have 7 minutes for the whole thing. And I'll start with the econ paper, no offense to the legal papers, but I have less to say on those. So the first theme I wanted to express is that is what I just said. The competition in business practices in digital markets is very complex. They're understanding the competitive process, understanding the contractual arrangements, understanding the way companies do things is complex. The second theme is related, and actually, let me say one more thing about the first one is that I think it's highlighted by some of the papers here, is that there's usually trade-offs. There's winners and losers. There's trade-offs between short-term effects and long-term dynamic effects. And so knowing how to intervene in these markets, either as a regulatory measure or remedies to antitrust cases, is very challenging because of all these trade-offs. And my second theme is that is related to that the trying to intervene in markets, especially in digital markets, going beyond preventing anti-competitive conduct. I think we can all agree that the antitrust law should prevent anti-competitive conduct, should remedy any harm done by anti-competitive conduct, but trying to intervene in ways that is disconnected from preventing that conduct, to try to re-engineer the marketplace, either the structure of the marketplace or the conduct of companies, is very likely to do more harm than good. There's a lot of room for unintended consequences, especially because of the dynamic aspect of these markets. So let me start up with some of the papers, and I'll start with Omar's paper about choice screens. And I think his paper highlights that what we would expect a remedy to do doesn't always pan out. He performs empirical analysis of choice screens in several different scenarios. And he correctly dismisses the fact that the concentration, high shares, are due to defaults, because when you implement a choice screen, it doesn't change shares very much. It doesn't change user choice, consumer behavior very much. And he concludes that the user choices are not driven by some sort of inertia or bias or consumer bias that is discussed in the behavioral economics literature, but probably driven by preferences and product quality. And so what I want to address in terms of this paper is, what does this mean in terms of the policy? Does this mean that we should implement more extensive, intensive regulatory interventions or less so? So what does it mean that a choice screen does not change the marketplace outcomes very much? Omar, I think in his paper, suggests that it might mean that we should implement more extensive regulatory interventions, such as altering defaults. And I think what that means is setting somebody else as a default. So Bing instead of Google. And I would say that's a very dangerous road to take. There's one of the reasons which people choose Google is because people prefer Google. And there's other evidence of that. There's other studies that have addressed that. There's one paper which I'm sure, Omar, you're familiar with, the Alcott paper, that also models the change in the default. And what they estimate is that by setting Bing as a default instead of Google, consumers would face a cost of $70 to $80 per user per year in lost consumer surplus. And the reason for that is because of the lower quality and lack of preference. And so essentially you're forcing consumers to face the cost of propping up rivals, right? It's sort of saying, these rivals are not as good. Let's force consumers to use them. So there's a question of why don't choice screens, and you address this, why don't choice screens have more of an effect? And I think one of the reasons is what we just talked about is, the default is consistent with user preferences. And it's not a coincidence that manufacturers such as Apple and Samsung choose the search engine that's most preferred by users as a default. If 98% of people prefer a certain search engine, why not set it as a default out of the box? It's one of the reasons for that. The other reason, which explains, when a worse quality service is set as a default, like in the Internet Explorer example that we can all agree was inferior, didn't have much of an impact is because in these digital markets, people already have a choice. People were already shifting to Chrome and Firefox. They were downloading it in different ways. And so, that's one reason why the choice screen itself doesn't have much of an effect. And this is one way in which choice screens and defaults in digital markets differ from the behavioral economics literature that looks at things like life insurance and 401k contributions. It's a very different scenario. So let me switch over. So I would caution about trying to re-engineer the market because of the lack of choice screen. And I want to turn to Yihao's paper about exclusivity just for a minute, which I think is a very impressive model, a very sophisticated model that models bargaining and price setting and consumer behavior. And he finds, I don't have to summarize it, you all heard it, but he finds very different trade-offs with exclusive contracts in video distribution. And this just, to me, that this just highlights that one needs a very sophisticated understanding of the competitive process and how these contractual arrangements and behaviors play the role that they play in the competitive process. In this scenario, I thought he made a very convincing point that exclusive contracts are not used to foreclose smaller rivals, but in fact are used by smaller rivals to differentiate themselves and to bargain. And this can have trade-offs in terms of short-term and long-term effects. In the long term, it leads to more content, and it leads to more competition from differentiated services. So I think that also highlights that if one were to take a blind eye towards restricting exclusive contracts, that might very well have unintended consequences without first understanding the real drivers of competition. And this is just one comment on Maria's paper about this. This is what I would say, which I found very, completely agree with your perspective, and I found your paper very, very insightful. But it's a little bit of economic knowledge a dangerous thing. It's use of words by some judges, is that a good proxy for economic sophistication? And I don't know how to deal with that issue, but it's consistent with Josh Wright and Michael Bay's paper that seminars actually improve the basic economic understanding, but not complex economic concepts. And so, it's the basic economic understanding. Is that a good thing or a bad thing? It's unclear to me. And I'll stop there because I know I've run out of time. Apologies for not getting to your thing.
Yeah, I've run out of time, and thank you to all of the presenters and discussants, and to Andres as the section discussant as well. Thank you very much.